Selling an investment property in Ontario is a significant decision that can have a lasting impact on your financial future and your relationship with your tenants. It can be even more complex when you have tenants in place, as their rights and needs must be carefully considered throughout the process. The good news is that it's perfectly legal to sell a tenanted property in Ontario, and many buyers are actually looking for homes with existing tenants. However, Ontario law has specific rules to protect both landlords and tenants during this process, ensuring fairness and transparency for everyone involved. This guide will walk you through the essential things you need to know as a landlord looking to sell your rental property, so you can avoid common pitfalls and make informed decisions. Understanding your legal obligations and following the proper procedures is crucial for a smooth transaction and can help you maintain a positive relationship with your tenants. Whether you're selling with the intention of the buyer becoming a new landlord, or if they plan to move in themselves, there are specific steps and considerations you'll need to address to ensure compliance with the law. This guide aims to provide you with a clear understanding of your rights and responsibilities as a landlord selling a tenanted property in Ontario, so you can move forward with confidence. It will cover key aspects, including lease types, tenant rights, showing protocols, notice periods, and potential scenarios you may encounter during the sale process. Remember, while this guide offers valuable information to help you get started, it should not be considered legal advice or a substitute for professional counsel. Consulting with a qualified real estate lawyer is always recommended for personalized guidance based on your unique situation, ensuring you meet all legal requirements and protect your interests. Selling your rental property doesn't change your existing responsibilities to your tenants. Even if you're in the process of transferring ownership, your obligations as a landlord remain in full effect until the very end of the lease, or until both parties agree otherwise. You must continue to maintain the property and fulfill the terms of the lease agreement until it ends naturally or through mutual agreement. This means you can't neglect repairs or ignore tenant concerns just because the property is for sale. This includes things like providing a safe and habitable dwelling, responding to repair requests promptly, and ensuring all essential services are in working order. You must also respect your tenants' right to quiet enjoyment of the property, allowing them to live peacefully without unnecessary disruptions. One of your primary responsibilities is providing proper notice to your tenants about the sale. This is not just a courtesy, it's a legal requirement. This notice should be given in writing and delivered according to the terms outlined in the Residential Tenancies Act. Make sure to check your local regulations for any additional requirements. Failing to provide adequate notice can lead to legal complications and delays in your sale, potentially resulting in financial penalties or disputes with your tenants. When it comes to showings, you must give tenants proper notice, usually 24 hours, and schedule them at reasonable times that don't disrupt their daily lives. You cannot force tenants to accommodate unreasonable showing requests or make significant changes to their living arrangements to facilitate the sale. Their comfort and privacy must be respected at all times. Transparency and open communication are crucial throughout the process. Address any questions or concerns your tenants may have as soon as possible. Keep your tenants informed about the sales progress and be upfront about any potential impact it may have on them, such as changes in ownership or management. This approach fosters trust and cooperation, making the transition smoother for everyone involved and helping to maintain a positive landlord-tenant relationship, even during times of change. When selling a tenanted property, the type of lease agreement you have is crucial. Ontario has two main lease types, fixed term and month-to-month. Fixed-term leases have set dates, and the new owner must honor the agreement if you sell. Month-to-month leases are more flexible and renew automatically. Either party can end it with proper notice, 60 days in Ontario. If the buyer wants to move in, they must use the N12 form. When a buyer wants to move into a property, there's a legal process to end the tenancy. In Ontario, the N12 form is used when a landlord or buyer needs the unit for themselves or close family. The landlord must give the tenant at least 60 days' notice and provide 1 month's rent as compensation. This compensation helps with moving costs. Misusing the N12 form can lead to serious legal consequences, so honesty and following the rules is essential. As you can see, Selling a tenanted property in Ontario involves careful planning, clear communication, and a solid understanding of your legal responsibilities. By following the right steps, you can ensure a smooth transition for both you and your tenants. If you have questions or need guidance tailored to your situation, consult a qualified real estate professional or legal advisor. Thank you for watching, and best of luck with your property sale. Ravi Bagla and Parul Bagla here from Remax Realty Services. See you in the next video.